Mr. Bean, does your client waive formal reading?
Judge, he does.
All right, Mr. Staples, good afternoon. This is a charge on an indictment of murder in the first degree. How do you plead for that charge?
I plead guilty. I'm sorry. Judge Kavanaugh. I plead no contest.
Raise your right hand and be sworn.
Do you swear to give true and perfect answers to such questions as may be propounded to you by this court, so help you God?
Yes, ma'am.
Mr. Staples, you're welcome to go ahead and have a seat, sir. Take your full name for the record.
Kenneth Carter Staples,
How old are you today, Mr. Staples?
43.
How far did you go to school?
Graduated high school.
Can you read,
Went to
write,
college for a while.
can you read, write, and understand the English language?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Do you fully understand the charge against you?
Yes, sir.
Have you discussed the charge and its elements with your attorney, and you understand what the Commonwealth must prove before it can be found guilty?
Yes, sir.
Have you also discussed with Mr. Dean any defenses you might have to these charges?
Yes, sir.
And have you discussed with him how you should plead?
Yes, sir.
After all of those discussions, you decide for yourself to plead guilty,
Yes, sir.
or excuse me, plead no contest. And you can plead freely and voluntarily.
Yes, sir.
You understand that in Virginia, a no contest plea is the functional equivalent of a guilty plea and is a tacit admission of your guilt on the crime charge.
Yes, sir.
Did you ask Mr. Dean about that? Did you understand?
We're good.
All right. You understand by this plea, you give up certain rights. For instance, you give up your right to be tried by a jury.
Yes, sir.
You give up your right not to incriminate yourself.
Yes, sir.
You give up your right to confront and cross-examine the witnesses against you.
Yes, sir.
You understand that if you're currently on probation, parole, or any suspended sentence over you, this guilty plea could affect those charges.
Yes, sir.
Does anyone connected with this case in any way threaten to force you to plead guilty?
No, sir.
Did they make you any promises other than what's in your plea agreement?
No, sir.
You understand the maximum punishment for this charge?
Yes, sir.
You understand that a felony conviction has civil consequences, such as loss of the right to vote, loss of the right to possess or transport a firearm.
Yes, sir.
Have we discussed the sentencing guidelines in this case?
Yes, sir.
And the court is not required to follow those guidelines. You understand not required to follow the guidelines.
Yes, sir.
You understand there's no parole for you to do.
Yes, sir.
You understand that by pleading guilty, you waive your right to appeal.
Yes, sir.
All right, the state will have this plea agreement in front of you. Did you sign this agreement?
Yes, sir.
Before signing it, did you either read it or have it read to you?
Yes, sir.
Did you fully understand it?
Yes, sir.
All right. So under the terms of this agreement, it says you will plead no contest to the murder charge that you've done. You understand that in return for that, the robbery charge will be now brought, that is not prosecuted by the Commonwealth. You understand that?
Yes, sir.
There will be a pre-sentence report and victim impact statements, and you understand that in the terms of this agreement, your active sentence shall not exceed 50 years.
Yes, sir.
Is that your understanding of what was supposed to be in your plea?
Yes, sir.
Did you understand all the questions that I asked you?
Yes, sir. I think so.
Did you answer all of the questions truthfully?
Yes, sir.
Do you have any questions for me?
Yes, sir.
Are you satisfied with the services of Mr. Dean?
Yes, sir.
Fine. Go back and you said I asked you if you understood all the questions, and you said you think so. Is there anything that you have any question about or are not sure about?
Yes, sir.
Okay. Now, Commonwealth, then, to summarize the evidence again.
Your Honor, by and between April 26, 2020 and April 27, 2020 in Alleghany County, Kenneth Carter Staples did unlawfully and feloniously, willfully and deliberately with premeditation kill and murder William Brandon Wright in the first degree. Between 5 o'clock p.m. and 7 o'clock p.m. on April 26, 2020, Penny Wright received a call from the defendant, Kenneth Staples, who was angry at her husband, William Brandon Wright, the victim in this case. Several weeks earlier, defendant's mother had driven him up from Georgia and dropped him off to live at the victim's house in Clifton Forge. This night, defendant was angry because the victim had asked him to leave, which defendant called a, quote, bitch move. During the conversation, defendant told Penny Wright that the victim was drunk and he might fall down the stairs and break his neck. Defendant went on to tell her that he could take Brandon out in 2.5 seconds, but he didn't have time to clean up all that blood. Penny became worried and contacted Elaine Marshall, the victim's mother. Elaine Marshall had spoken to her son over the phone during the same time period on April the 26th, 2020. During the phone call, Elaine Marshall heard defendant come into the house and heard the victim tell the defendant he couldn't stay there anymore. She heard the defendant yell something that she could not make out, after which the victim replied, "What did you say?" The call was disconnected, and 10 to 20 minutes later, she received a text from Brandon's phone that said, "Call me." Marshall tried numerous times to call her son after that with no response. After repeated unsuccessful attempts to reach the victim, Penny Wright contacted the Clifton Forge Police Department. On April the 27th, 2020, at approximately 2 p.m., Officer Sean Urban responded to 907 Jefferson Avenue to conduct a well-being check on the victim, William Brandon Wright. After getting no answer at the door, Officer Urban looked through the window and saw a human body covered with a blanket lying face down on the floor. He also noticed copious amounts of blood on the walls and floor. Officer Urban kicked in the front door and found William Brandon Wright deceased with multiple blunt force trauma wounds to the head. Surrounding the victim's body were bloody saturated towels, a mop, and numerous blood-smeared bottles of cleaning products apparently used in an effort to clean up the blood. Officer Urban described an overwhelming odor of mixed chemicals, including gasoline, which made it difficult for him to breathe. The Clifton Forge Police Department, together with the Virginia State Police, photographed and processed the crime scene. Photographs and bloodstains chronicled a prolonged struggle that began near the top of the stairs and continued with repeated blows past the first landing and down to the bottom across one room and into the next. 3 buttons and a clump of hair were found on the stairs amid the blood. Based on the increase in blood volume of the stains as they progressed down the stairs, experts opined that the first impact occurred near the top of the stairs. Blood spatter analysis determined that many of the bloodletting blows impacted the victim at heights between 15 and 35 inches from the stairs and stair landing. A bloody pair of defendant's red Converse sneakers, size 11, sat next to a blood-stained mop. A lab analysis revealed that the Converse had the victim's blood spatter on them, indicating that they were in close proximity to the victim at the time of the bloodletting impact. A cell phone battery was found on the stairs with blood smears matching the victim's DNA. DNA certificate of analysis and bloodstain pattern analysis will explain further. After attempts to clean up, defendant fled the scene in the victim's white 2015 Ford F-150 pickup truck headed for his home in Georgia. On his way through Botetourt County, defendant stopped at the Daleville Kroger the morning of April 27th around 7:21 a.m. to buy beer, where he was captured on store video. He continued through North Carolina and South Carolina, where he borrowed cell phones from strangers to call his mother in Georgia. Witness Courtney Cabrero notified Virginia State Police that when defendant, who was wearing a ball cap, used her cell phone at the XL gas station in Spartanburg, South Carolina, he was driving the victim's Ford F-150. When the defendant got as far as Atlanta on April 27th, he called his mother and asked her to pick him up at a gas station near Atlanta. Authorities determined that Gail Staples, his mother, left her home in LaGrange, Georgia about 11:30 that night to pick up the defendant at a Chevron station just off of I-285 in Atlanta. Defendant abandoned the victim's F-150 at the Chevron and transferred its contents to his mother's Ford Edge. Investigator Zach Phillips from the Troup County Sheriff's Office recovered the stolen F-150 and the victim's size 14 shoes, which were found 10 yards from the truck. On April the 28th at approximately 11:26 a.m., Troup County Sergeant Jeff Adams and investigator Kendra Scott spotted Gail Staples' Ford Edge. Deputies could observe defendant Kenneth Staples lying back in the front passenger seat in an attempt to conceal himself. After stopping the vehicle, deputies were able to take the defendant into custody. Virginia State Police Special Agent Tommy Morris and Clifton Forge Police Sergeant Travis Ledford traveled to Troup County, Georgia to process both vehicles. Located with the defendant in his mother's Ford Edge, authorities found the keys to the victim's F-150 and the victim's wallet containing his driver's license, social security card, and other items. The defendant's gray Nike sweatpants found in the Ford Edge cargo area were determined to have the victim's blood spatter on them. The defendant's baseball hat, located in the floorboard where he was sitting, was also stained with the victim's blood. A blood-stained gray and black glove found near the sweatpants showed the presence of both the victim's blood and the defendant's DNA. An autopsy was performed on the victim by medical examiner Dr. Gail Suzuki, who determined the cause of death to be blunt force injuries of the head The manner of death was listed as homicide. Autopsy findings revealed multiple bruises and lacerations to the head, which are detailed in the autopsy report. As Commonwealth Exhibit 1, Your Honor, we would offer into evidence the written summary that we have just read. As Commonwealth Exhibit 2, the Virginia State Police Activity Report that details all of the pieces of evidence by number that were recovered from the scene, and they will correspond to the DNA certificate. As Commonwealth Exhibit number 3, an autopsy report by Gail Suzuki. As Commonwealth Exhibit number 4, the DNA report that details all the findings and additional findings, and that was authored by Patricia Taylor, forensic scientist. As Commonwealth Exhibit 5, a supplemental DNA report that is the analysis of the black and gray glove found in the F1 in the Ford Edge. As Commonwealth Exhibit number 6, a blood pattern analysis, a stain analysis from the shoe print that was found at the scene, authored by Corey Bartow. As Commonwealth Exhibit number 7, the blood pattern analysis report that was mentioned in the Commonwealth summary. As Commonwealth Exhibit 8, a crime scene diagram prepared by Special Agent Tommy Morris. As Commonwealth Exhibit 9, crime scene photographs from the first crime scene at 907 Jefferson Avenue. The photographs are numbered 1 through 68. As Commonwealth Exhibit 10, crime scene photographs that are the bloodstain patterns that are referred to and used in the bloodstain pattern analysis. As Commonwealth Exhibit number 11, the photographs from the crime scene in the 2013 Ford Edge. As Commonwealth Exhibit 12, photographs of the white truck that was recovered from the gas station in Atlanta. All these events did occur in Alleghany County.
Mr. D, any objections to the admission of the Commonwealth exhibits?
No, Judge.
Any additions or corrections to the summary of evidence provided by the Commonwealth?
Judge, by way of addition, Mr. Staples and Mr. Wright were childhood friends. They had known each other since they were about 8 years old. They considered themselves to be brothers. And had this case proceeded to trial, Mr. Staples would have testified that he had moved to Virginia about 3 weeks prior to the offenses. He said that his friend, Mr. Wright, had invited him to stay together after Mr. Wright's wife left him. And Mr. Staples recalled that Mr. Wright was pretty upset. He slept a lot during that time period. They looked for work. They spent a lot of time looking for a job and seemed to be getting along pretty well. On the evening in question, it started out as a normal day, but they had both been drinking vodka just about all day. Mr. Staples didn't remember feeling intoxicated at the time. However, his friend had wanted to go to the ABC store and purchase more alcohol. When they returned home, he recalls a fight breaking out between the two of them for some reason. Mr. Staples would have testified that Mr. Wright had started cussing, and that essentially Mr. Staples was trying to go for a walk to get out of the house, but that they began ranting and raving, and Mr. Wright punched him. In response, Mr. Staples, who has considerable size and he's had experience in the past in terms of mixed martial arts fighting, had hit Mr. Wright in response and knocked him off balance, and the two of them began fighting one another, but Mr. Staples, using his fists and his elbows, hit Mr. Wright 3 times in the head. And it's when he punched his friend in the stomach, his friend, Mr. Wright, started throwing up large amounts of blood. He was worried that his friend, that an organ or a liver or something had burst, and that caused the huge amount of blood that Mr. Wright was expelling from his body. Mr. Staples goes in and out of consciousness after this. He eventually passes out next to him. He wakes up in the morning and realizes what had happened. He makes brief attempts to try and clean up. He's not sure what to do. He's distraught because he realized he had murdered his best friend. And so in that particular period, he leaves. He drives all the way to Georgia because that's where he's from. He eventually meets up with his mother. He expresses paranoia about what had taken place, and he proceeds to obtain psychiatric treatment over many months afterwards because he was in a state of shock that really didn't live for a very long time until recently about what had taken place. Mr. Staples is now in his mid-40s. He doesn't want to die in jail. Had this case proceeded to trial, there is a significant risk of a life sentence in knowing that Virginia has abolished parole. He's entered this no contest plea to avoid the risk of a conviction and a sentence of a life sentence after a trial in this case. He appreciates the Commonwealth giving him the opportunity to cap his active sentence that gives him a glimmer of hope at geriatric release in old age. He's done well for himself in jail. He's been incarcerated ever since this took place, of course. He's had no infractions, no issues that we're aware of. There is more to say about his mental health and mental illness at the time of the offense when this matter proceeds to sentencing. But for today's purposes, we ask that you please accept the plea agreement, which was reached after a compromise between the Commonwealth and the defendant based on consultation with Mr. Staples. He asked the court to accept it. Thank you.
All right, Mr. Staples, if you please stand. Mr. Staples, as you find you have been present throughout this proceeding together with your attorney, as you find it completed, no contest has been made knowingly, freely, and voluntarily, without any fraud, duress, coercion, or intimidation. You further find you understand the nature of consequences of your no contest plea, the penalties you're facing, the rights that you're giving up, as you find there is a factual basis to support this conviction, and that you have been ably and capably represented by counsel. Based on these pleas of no contest, some evidence finding the court was finding guilty of murder in the first degree as set forth in your indictment. You will not be sentenced at this time. Instead, we will have a sentencing court. We will set a date for sentencing. At that time, you have to hear anything that you want to say. The charge of robbery will be not processed by the Commonwealth without objection of the defense. All right, let's look at the sentencing date. January 9th look.
That should be fine.
Judge, that works for me.
All right, how long do you anticipate for sentencing?
I would say 2 hours.
At least.
Yeah,
All right, you know,
if a morning docket or an afternoon.
well, let's just put it at 1 o'clock.
Very good.
January 9th at 1 o'clock. All right, so Staples will remain in custody. We will see you again in court.
Yes, sir. You see this? Yes, sir.
All right, the court will be in recess, and then we'll gather the jury back for the other case.
Thank you, Your Honor.